Ever get the feeling your HOA is spending your dues behind a curtain? A special assessment lands out of nowhere, the reserve fund looks thin, and every question gets a shrug. Here's what most homeowners never realize. In nearly every state, you have a legal right to look at the books, the budget, the bank statements, the contracts, the meeting minutes, and the board can't just say no. In the next few minutes, I'll show you exactly what you can demand, what they're allowed to hold back, how to ask so they can't stall, and what to do if they try to. Start with the mindset shift, because it changes how you'll act. These aren't the board's private files, they're the association's records, and as a dues-paying member, you're a part owner of them. The right comes from two places at once, and that's your leverage. Your own CC&Rs and bylaws almost always spell out an inspection right, and on top of that, most states have a statute that forces the issue. Florida, for example, says the official records have to be made available within 10 business days of a written request. Notice that word written. A verbal ask at the mailbox starts no clock and creates no obligation. The paper is what turns your curiosity into a deadline the board has to meet. So why bother pulling all this? Because the records are where the story lives. Say your dues jumped 20% and nobody explained why. The general ledger and the bank statements will show you whether that money went to a real roof repair or to a landscaping contract that happens to belong to a board member's brother-in-law. That second thing has a name, self-dealing, and it hides beautifully in a budget summary, but not in the actual invoices and canceled checks. The classic pattern is a surprise special assessment. The board drained the reserves quietly, and the first the owners hear of it is a bill. If you'd pulled the reserve study and the statements 6 months earlier, you'd have seen it coming and had time to organize before the vote. Now the board isn't wrong that some things are off limits. The trick is knowing which, so they can't overuse the exceptions as a shield. The green light pile is big: budgets, income and expense statements, the general ledger, meeting minutes and agendas, and the signed contracts with vendors. The genuinely protected pile is narrow and specific. Anything covered by attorney-client privilege, the board's confidential legal advice, stays private. So do employee personnel files and any other owner's sensitive personal data. Social security numbers, medical information, bank account numbers. Here's where people get played, though. A board will sometimes stamp privileged or confidential on an ordinary contract to keep you out. A routine landscaping agreement is not legal advice. If the exemption doesn't actually fit one of those narrow buckets, it doesn't hold, and you can say so in writing. Here's the part that actually gets you the documents, and each step is doing a job. Step 1, writing, isn't a formality. In Texas, the statute even wants that request sent by certified mail, so there's proof of the date. Look hard at Step 2, because vagueness is the board's favorite escape hatch. Send me the financials invites a one-page summary and a shrug, while the general ledger and bank statements for January through June of this year leaves nowhere to hide. Step 3 is quietly powerful. When you cite the deadline in the letter itself, you've shown them you know the clock exists, and boards behave very differently when they know you're counting. Step 4 just keeps you calm. Yes, they can charge a small per-page copy fee, so don't cry foul over a few dollars. And Step 5 is the one people skip and regret. If the deadline passes, your follow-up has to be in writing too, because that paper trail is the exact evidence you'll need if this ever escalates. This is where knowing the actual numbers pays off, because, we'll get to it, is not a legal answer. The response window is measured in days. California is a good illustration. Records from the current fiscal year generally have to be produced within about 10 business days, and older records from the prior couple of years within about 30. Texas gives the association 10 business days too, with one limited extension if they notify you properly. The point isn't to memorize any single state, it's to know a real deadline exists and to hold them to yours. Same story on money. The fees are capped and have to be reasonable. Florida pins photocopies at a few cents a page. So if a board suddenly quotes you hundreds of dollars to cover administrative time, that's not a fee, That's a wall, and an unreasonable one is itself a sign they're hiding something. Here's the leverage that flips the whole thing around. In a lot of states, missing the deadline costs the association, not you. Florida actually puts a dollar figure on foot dragging, $50 a day, for up to 10 days when they wrongfully fail to hand over records after your written request. California goes further at the finish line. If you have to sue to see the books, the court can order them to open up, make them pay a civil penalty for each denied request, and stick them with your costs and attorney's fees. Read that last part twice. The board members deciding to stonewall you are gambling with the whole community's money, including their own dues. That's exactly the argument that tends to unstick a stubborn board. This is going to cost the association far more than it costs you. Keep this table as your cheat sheet, because the pattern down the left column is the whole game. Money, decisions, deals, people, planning. The association's operational life is open to you. Run your eye down the right column and notice what it protects. It's almost always someone else's privacy or a genuinely confidential legal matter, not the board's comfort. That distinction is your test. When a board denies a request, ask which specific bucket on the right it falls into. The minutes are confidential, fails that test instantly, minutes are on the left. That's in a personnel file might pass. And that middle row on decisions is where boards blur the line most. A real executive session about litigation or a specific employee can stay closed, but a board can't just relabel its ordinary business executive session to keep the minutes from you. Now a right that pairs with the records and that too many owners sleep on. You don't have to wait for a document to find out what your board is doing. You can be in the room. In most states, board meetings are open to members. You're allowed to attend, and you generally get to speak on the items being voted on. And the board can't meet in secret. They owe you advance notice of when and where. Florida wants it posted at least 48 hours ahead, Texas 6 full days before a regular meeting. The only real carve-out is executive session, for narrow things like active litigation or a personnel matter. The move that catches boards off guard is combining these rights. Show up to the meeting, and afterward request the minutes and any contract that was approved. Now you can check the official record against what you watched happen with your own eyes. Most requests that die don't die because the board is evil. They die because the owner made one of 3 unforced errors. The first is asking out loud. You corner a board member at the pool, they say, "Sure, remind me," and legally nothing has started. There's no clock and no proof you ever asked. The second is being vague. "I want to see the finances," lets them hand you a tidy 1-page summary that reveals nothing, and technically call it done. The fix is naming the exact document and the exact dates. The third is going quiet after the deadline slips. Boards read silence as surrender. If you don't send that written follow-up, you've not only lost the records, you've thrown away the paper trail you'd need to enforce your right later. Written, specific, and persistent, that trio is 90% of the whole battle. So what if you've done everything right and they still stonewall? You climb the ladder, and you don't have to start at the top. Often a firm demand letter, ideally on an attorney's letterhead, is enough on its own because now the board sees a real cost coming. Many disputes can go to mediation next, which is cheaper and faster than court. And in some states, forcing an inspection is squarely within small claims range, meaning you may not even need a lawyer to get in front of a judge. But manage your expectations about the state cavalry, because it varies wildly. A few states have a real HOA regulator, and many don't investigate these complaints at all. So before you pin your hopes on reporting them to the state, find out what your state actually offers, and if there's a lien, a big dollar figure, or anything that smells like retaliation for asking, that's your cue to bring in a licensed attorney rather than go it alone. Let's tie it together so you can act today. First, reframe it. These are the association's records and you have a right to see them. The board's honest default is yes, here you go, not no. Second, ask the right way in writing, naming the exact documents and dates, citing your statute and flagging the deadline right in the letter. because how you ask decides whether you get paper or a shrug. Third, know the line. Budgets, minutes, ledgers, and contracts are open, while attorney-client privilege and other people's private data are the narrow things they can hold back, so make them justify any denial against that short list. And last, if they stall, remember the leverage runs your way. Missed deadlines can cost the association real money, and a court can force the doors open and hand them your legal bill. Written, specific, persistent, that's how you go from shut out to fully informed. This video is general education, not legal advice, and the rules around HOA records, which documents your owed, the deadlines, the fee caps, the penalties, and where you can escalate vary by your state and by your community's own governing documents. It was researched and produced with AI assistance, including script research, voice, and on-screen graphics, and reviewed by a human against the cited sources before publishing. Before you act, read your own CC&Rs and bylaws. Check your state's HOA record statute. And if a board refuses you, a lien is involved, or real money is at stake, talk to a licensed attorney in your state.